September. We're going to wait a moment and make sure everyone's in from the waiting room. And it looks like we're all here. Thank you for joining us today. I'm Jennifer G. Winter, one of the associated attorneys with Condominium Law Group. I'm here with Ken Harrer. We're going to start, as we do normally, with our Zoom housekeeping tips. So you should see the message notification flashing. There was some information put into the chat. If you want to start and stop your video, that should be at the bottom of your screen, depending on what device and platform you're using. Your mute and unmute button is there as well. We ask that you all stay muted in order to reduce background noise. If you want to ask a question, please feel free to put that in the chat. You can also unmute yourself to ask for clarification. The chat function is not meant for discussion like you see on the CAA message boards. It's just for asking for clarification or asking a question. Please be reminded as well that this entire Zoom is not intended as legal advice. Please don't contact our office and say, well, you said this in the Zoom, but you're telling me this differently. And part of the reason for that is because we cannot know everyone's particular facts and circumstances. So if you're one of our clients and ask us a question, you will get a more detailed answer for your specific community and your specific situation. We can't cover that here because we're not giving legal advice. So, over the past few months, we've been doing short primers at the beginning of some of our Q&As. These primers are on topics that come up fairly often or are discussing legislative changes. So if you have questions about when the meeting statute comes into effect or how meetings should be conducted with the new changes, please go back to our YouTube channel and search the prior Zooms, and there will be several Q&As and questions that have popped up regarding those particular issues. CAI also has a WUCIOA guideline or resource guide for sale. Proceeds from the sale go to the Legislative Action Committee. I'm sorry, I can't talk this morning. The Legislative Action Committee pays for CAI's lobbyists that will go to the legislature and lobby with particular legislators for changes to statute or things that would help our community as a whole. So if you want to be involved or take a look at that resource guide, please go to WSCAI.org and you'll find that information there. CA Day is October 18th. That's coming up. Katie from our office will be presenting this year on meetings and the new meeting statute. We'll have a booth there. All of our attorneys will be there at different times. Please feel free to stop by so you can meet us in person. We'd be happy to talk with you. And it's a great time, so please feel free to go to the WSCAI website and sign up to go to the to CA Day. It's a lot of fun. So just briefly, changes to WUCIOA took effect for WUCIOA committees on July 27th of this year. So if you have adopted WUCIOA as your statute or your community was formed after July 1st, 2018, you are a WUCIOA community, and the meeting statutes already apply to you. For every other community association in Washington state, those statutes will come into effect January 1st of 2026. So this is for meetings and collections notices. All other changes for communities that are not under WUCIOA come into effect January 1st of 2028. So if you have questions about that, please feel free to put them in the chat or go back to our previous Q&A as we've been discussing this quite a bit. So one last housekeeping tip or information, just general information. The state bar puts out a magazine. I can't remember if it's every month or quarterly, with various topics for attorneys to take a look at. And one of the articles from the latest bar news was on WUCIOA. So if you want to take a look at that, go to the Washington State Bar or just search for Washington Bar Association, WSBA, and that should be on the main page if you want to take a quick look at that. And I believe Ken was going to do a quick primer on owner complaints and enforcement. Did you have anything else, Ken?
No. So we get a number of questions which relate to one owner complaining about their neighbor and demanding that the board take action to fix something that the neighbors decide is a problem. And this might be noise complaints or view obstructions or complaints about dogs or there's a large variety of things that happen. And so what I had put together was a kind of short version on what the board's obligations are with regards to enforcement. And a lot of boards don't want to have to deal with it, and I understand why. A lot of times the complaining owner is being unreasonable. Doesn't mean always, but part of the question is, how do you deal with it? And so that's what I'm trying to start with. The first thing is that first, only the board can decide if a violation has actually occurred, not an owner. So the fact that one owner, complains to the board and says the garbage cans have been left out overnight, or complains about the dog being off leash, or whatever it is, that is not enough for a board to find a violation. Okay. And it may be that it's true it's a violation, but that one owner complaining is not sufficient to create a violation. The board has to actually decide whether or not there's a violation. And part of that is the board has to inquire and use objective information in making its decision. This is a standard set out by a case called Riss v. Angel. This case has been cited nationwide as establishing what the board's duty of care is in terms of looking at information. And so if you've got a complaint, the obligation to deal with the complaint exists. You can't just ignore it. You have to do some inquiry and you have to use objective information. If all you've got is one neighbor complaining to the board about another neighbor and no other information, you probably don't have objective information to support finding a violation. So you'd have to inquire, and some things are going to be difficult to establish that a violation has occurred because they may be very transitory in nature. Something like a noise violation is a good example. If the board can't actually determine through objective information that the noise is unreasonable, they can't find a violation, no matter how often the complaining owner is going to, object to it. Okay. If it is a violation of law, whether it's a building code or animal control or something like that, the board can let the police decide or the city county planners decide whether or not a violation of the law has occurred, and they can leave violations of law to be enforced by the police or the city. Okay. The board is not required to take action on all those. Many governing documents are written so that a violation of law is also a violation of the declaration. But it's okay to let the police decide whether a government standard has been violated rather than the board trying to take that on themselves. Okay. And remember, these are general rules, not legal advice. If the board has a complaint, they can schedule at their board meeting to deal with the complaint rather than try and respond, immediately to some owner demanding action. Boards have to act as a group. They have to put things on their agenda under the new laws, which are taking effect in January. So the appropriate thing in most cases for a violation complaint is for the board to respond or the manager to respond, whoever gets the complaint, to say, hey, we got your complaint and we will put it on the agenda for our next board meeting. And then at the next board meeting, if there's time on your meeting agenda, you address it. You do not have to respond if the owner who's complaining sends you 15 emails about it. You can send the same basic response as that you've gotten the complaint, and it'll be put on the agenda for the next meeting. Hopefully at that meeting, then you can do your inquiry and use objective information to make a decision on whether a violation has occurred. So once the board has made a decision using objective information and adequate inquiry, you're either going to decide there is a violation of your governing documents or there's not a violation of the governing documents. If there's no violation, the board or the association takes no other action than to inform the parties that they determined there was not a violation. Okay. And even if there is a violation, the board then has to decide what, if any, action it's going to take to enforce the violation. And the options are you take no action because it's not in the best interest of the association. You send a warning letter or a fine and follow whatever the process is that you have in your governing documents for enforcement. Or 3, you can sue the owner in court so that you can try and get a court order demanding that the owner comply with the governing documents. We have a lot of clients who somehow think that we can provide some kind of, of power to the association to evict tenants who are improperly in their units, or get owners to stop using limited common element attics as storage spaces, or that we can tow cars from people's driveways if they're parking overnight and they're not supposed to. The reality is, besides fining, you don't have the ability to take physical action unless you get a court order. And very few of our clients want to spend the time or money or energy to sue one of their owners over violations. And we understand that. We could certainly sue a lot of owners on behalf of the associations, but it's something that we don't generally recommend our clients spend money on, and it's not going to be an action which will create a harmonious and neighborly kind of community to live in. So we have a lot of owners who are complaining, who are very upset that the boards don't take more action. And one of the things that I try and make sure that the boards understand is that the individual owners have that same power to sue their neighbor to enforce the CC&Rs or the condo declaration. That is not a power exclusive to the board. Only the board can assess a fine, but if one neighbor is convinced that their next door neighbor or someone else in the community is violating the covenants because of something they built or where they park or how much noise they're making, they have the ability to go to court and get a court to rule that that's a violation of the documents and to impose an order on the neighbor. It's true that they can do that even if the board has if they disagree with how the board has evaluated a complaint. So the board could find no violation and an owner could still sue to get the court to find that there was a violation. A board could choose to take no action and the owner can still sue to get the court to issue an order to require the neighbor to do something. So it's not that the owners are powerless if the board disagrees with what they want to do to enforce. The individual owners have all the power themselves to do that, to use that same remedy. It's provided for in the statutes, and it is written into almost every set of CC&Rs or condo declaration. Okay. So we've also had come up recently the issue of, well, how do boards evaluate these complaints with the open meeting requirements that come with the WUCIOA for all in January of this coming year? And I think my general answer would be just do it in open meetings. And there is an argument that could be made, and it's going to be really case specific, that privacy concerns could justify the use of an executive session to deal with some complaints and some violations. And we don't know what the legislature meant when they put those terms in. And so it's going to be really specific to the type of violation or the parties involved, whether or not we think it's appropriate to do an executive session. But remember, you have to actually start an executive session in an open meeting. So you'd have to, at the open meeting, have a vote to go into executive session to discuss the complaint or the violation. And then after the executive session, you'd have to have the motion made in the open meeting on how you're going to enforce, or that you're going to decide there is no violation. There has to be more transparency than many communities have used in past practice. And for communities which are self-managed, I think that you should keep in mind that hiring a manager is one way of reducing the burden on the boards to deal with all of these kinds of issues. It costs money, but it is something which, if you're having problems and you don't want to deal with owners, who are making repeated demands during the course of a month, part of what managers do is insulate boards. A lot of owners just are not willing to accept that the boards have to meet in order to take any action. And especially the way the new statute's written, the board's supposed to provide 14 days notice to all owners of the meetings. And so if you've got an agenda item to deal with some kind of violation, theoretically, you've got to give 14 days notice to the whole community before the board can meet and have an open discussion about that topic. And it'll be interesting to see how some of this plays out. The statute's really clear, but the practical aspects of trying to comply are not so clear. And so it's going to be I'll say a learning experience as we start to see more and more communities try and comply with the statute and try and document the decisions they're making and be consistent so they're not appearing to be discriminatory towards certain owners. Jennifer, do you have things you want to add to any of this?
I don't, well, two quick issues that I wanted to kind of reiterate is that number one, boards do not have the authority to enforce statute. Criminal statute, no. That belongs with the police and the criminal justice system. If someone is complaining to the association about a violation of law, the first thing that they should be told is to contact the police. The association does not have the authority to issue no contact orders or to try and seek a protective order, meaning a no contact order for an individual or even for the board as a whole. Individual owners have more authority than the association when it comes to issues like this. But if you have questions, contact your association attorney. If you have problems with figuring out whether or not something's a violation, contact your association attorney. This is one area where getting advice quickly at the beginning of the problem will make dealing with the issue long term much, much easier. So, two quick questions in the chat. What if the complaint is about a board member? Please remember that outside of a meeting, board members are owners and have the same authority as every other owner. It's only when they have delegated authority by the board that they can exercise that authority outside of a board meeting. So if a complaint is about a board member, it needs to be investigated. You follow your same process. That particular board member probably shouldn't vote to determine whether or not they violated the governing documents. But just because they're a board member does not insulate them from enforcement. And then the second question is, does the board always need to vote to go into executive session? Yes.
Right,
That
because that's the way the statute's written. You always have to vote to go into executive session, and you have to state the purpose for the executive session, and you're only allowed to discuss the topics that are in that purpose.
and in the statute. So right now, potential violations of law for 6438 HOAs are allowed to be discussed in executive session. That changes starting January 1st of 26. And that particular part of the statute goes away. So violations are open if there is a particular concern regarding a particular violation or a particular situation that can probably be dealt with in executive session, but you can't just blanketly state all enforcement is going to be handled in executive session. That's probably a violation of statute and not something that we would want to argue in court. So, Ken, did you have anything to add to that?
No, I think we can move on to the questions submitted.
Okay, so the first question comes from an owner. It starts with a little confused about the WUCIOA law that goes into effect. If your condo board adopted the WUCIOA in 2024, but were under the Horizontal Property Regimes Act prior to 24, are the new laws retroactive? In other words, which laws would apply to my condo association follow if the request is for something that happened prior to 2024? I was told by my condo board president my request was denied because the old laws did not allow for that request, but the new laws do. Since the request was for something that happened prior to the acceptance of WUCIOA, they would not provide that information because they were under the old laws, which do not allow for that particular item. So we're not sure what you're asking about or for. In general, if this is about association records, the statute in place at the time the records request was made is what controls. So if the association has the documents, they should be provided. With caveats, there are particular issues in the statute that state certain information may be redacted. So if the redactions, if the information that you're asking for needs to be redacted, that needs to happen. Please also be aware that statute allows the association to impose a reasonable cost for producing and supervising inspection of records. So there are some caveats there and some back and forth. If the association did not maintain a particular record that you're asking for, it doesn't have to create it or provide it. If it doesn't exist, it doesn't exist. If you, in other words, if you ask today, WUCIOA applies even if the records are pre-adopting WUCIOA. If you're asking me about something else, it's probably too specific for us to answer, and please contact an attorney. Ken, did you have anything to add to that?
Well, I'll try for something that's not specific to records. So the trying to decide what statute would apply when you have switched like this will depend on when the event occurred. So, for example, the new statute requires audits for every community with a budget over $50,000. But if you were under the previous statute before 2024, you don't have to go back and audit 2022 and 2023 because those were events that occurred before the new statute. But after the new statute was adopted, you would have to do an audit. So it's going to start being very specific to what you're asking about. And again, we didn't know what you're asking about. Next question. What are some options available to the association members when the board decides not to follow state law and its own governing documents? So we've answered a lot of variations of this in the past. And, the short answer is you can talk to the board and try and get them to understand what their obligations are. You can call a special meeting of the members to remove the board because you think they're not doing what they're supposed to do. You can try and get elected to the board yourself. You can try and find an attorney to give you advice. You can sue the association to get a court order to require the association to comply. There's no silver bullet for getting other people to agree with you that something needs to be done. And there's also a lot of times where there's a gray area about whether or not something is or is not in compliance with the state law or your governing documents. In fact, there's a lot of gray areas is why we end up with so many law firms practicing in this area of law now. Anything you want to add, Jennifer?
No, I think you've covered it. Our next question is, few people want to submit a complaint against a neighbor, and few boards want to police their neighborhoods. So what's the best practice for self-governed HOAs to maintain the appearance of their communities without risking liability for selective enforcement? Let's say a homeowner submits a complaint to the board about a scruffy yard. The board sends a violation notice. Does the board have any obligation to send notices to owners of other scruffy yards in the neighborhood? If not, can individual board members be the ones to submit complaints that single out homeowners? Lastly, can the board promise homeowners that their names will be redacted from their complaints? If so, what if the violator is a board member? And then just a quick comment, wishing for a bright line that probably doesn't exist. And that's correct. There is no bright line. Ken covered a lot of this question in the primer, but best practices have clear rules on expectations for things within the association's authority to regulate, have a fine and enforcement policy that outlines the steps and opportunity to be heard when there's a violation, perform reasonable investigation of all complaints and reflect that investigation in board meeting minutes. If an owner complains about getting notice and there are other potential violations, so the issue when a homeowner says, why are you enforcing against me when so-and-so across the street has the same issue? Honestly, in that particular instance, the board can say, thank you for bringing that to our attention. We will take a look and follow up with that as needed. So in general, only the board has the discretion to determine whether or not enforcement is worth pursuing in a particular instance. The board has the sole authority to determine whether or not a violation has taken place. So the statutory reference for if enforcement is not in the best interest is 6490-405, subsection 7 through 9. So that's the board's general authority to determine whether whether or not a violation is worth pursuing. Most governing documents allow owners to pursue enforcement on their own. Complaints can be submitted by anyone within the community. In general, complaints probably cannot be kept anonymous. The record of the complaint may be disclosed to the owner whose unit or lot is involved on their request. So that authority is 6490-495, sub 1, sub K. and sub 3, sub H. So individual board members can report violations. You need to be careful that violations are not found for discriminatory purposes. That is, you don't like one, you like a particular owner. So if a complaint comes in about that owner, you say it's not worth pursuing. Same complaint comes in about another owner, and that one is being pursued. There, there are so many different permutations and uh, issues with enforcement that gets really, really fact specific. Just contact your association attorney if you have questions regarding enforcement and enforcement procedures. In this particular instance, it's better to get advice early and often so you don't wind up having a lawsuit or have other problems later. Ken, did you have anything to add to that?
Yeah, so one way of avoiding at least accusations of discriminatory or selective enforcement would be to have some kind of a routine where you did a cursory inspection. And we have a number of clients that do this, or where their managers do this, where they will drive through the entire community and look at all the yards so that they are reporting all of the scruffy lawns to the owners instead of just the one scruffy lawn next door to the board president. And that is a reasonable way of trying to get compliance. It's at least predictable. And it is a way of making sure that the same standard for enforcement is applied throughout the community. And certainly individual board members can take it upon themselves to do that if the association is not doing it otherwise. But I'd probably recommend that if a board member is doing it, they should be looking at all of the neighbors instead of just the one next door to them. And some communities really do care about the garbage cans being pulled in by 5 o'clock every day, or not having any weeds in lawns. And it's okay to have that standard in a community. There are some people who buy into communities just so they can have that very high level of maintenance and care, and they will be in a community that looks like that. And so if that's the community you want to have, that's okay. You do need to be consistent in your enforcement so that it doesn't appear to be discriminatory. Next question. My question is regard to the ACC committees. The CC&Rs for our community established in 2020 state that the board will appoint 3 members to the Architectural Control Committee, and that the ACC has full responsibility for reviewing plans, making decisions to approve or disapprove a request. They meet privately at their convenience and issue their decisions to owners within 30 days. There are no board members on the committee. Is this approach allowed under the current statutes, or is it being defined to operate this way because our CC&Rs have provided for it? So the first thing is that, we can't give you legal advice on this, and especially because we haven't seen the documents to review. My response is that the general rule is any 2020 community is covered by WUCIOA, and I would say that every committee exercising board power has to have at least 2 board members who are the only voting members on the committee. And because the board is appointing this committee, I would suggest that it is actually exercising board powers, and therefore it is going to have to comply with the requirement to have 2 board members, and it's going to have to comply with the open meetings requirements and provide for an owner comment period at the beginning of their meetings. Now, certainly in the past, under the prior statutes, there are some courts which have held that a architectural control committee, which is created by the governing documents and not by the board, is allowed to exercise independent authority. But because in the sample that's been provided to me, it says the board appoints the members, I would default to say that it's going to be a board committee. And so if you're having concerns about this, I would suggest that you present the actual information from your CCNRs to an attorney and let them give you advice. Certainly the safe thing to do is have open meetings, because that is going to be less subject to any kind of challenge from an owner or through the courts. And one of the things we try and do is encourage our clients to do things which are low risk options. Usually they're less expensive anyway, and it insulates them. Do you have anything you want to add, Jennifer?
Just briefly, even if you're not a WUCIOA committee, WUCIOA community, the best practice is to hold open meetings. Just start following the statutes. They're going to be come into effect in the next 4 months. It's easier, more cost effective, and causes less problems to just hold open meetings. You don't get, it's less likely to get conspiracy theories. Also remember that committees are required to have minutes, and statute requires that any material used by a committee to determine modification requests, that information must be kept for 7 years. So even if you're having closed meetings, information must be made available to owners. Ken, did you have anything to add to that?
No, I'm good.
Okay. So our next question is under RCW 6434. Is there a time limit for approving a proposed amendment such as 11 months? So this voting procedures were added to all statutes in 2021. So please Google your whatever statute you're under, 6432, 6434, 6438, or 6490, excuse me. And just Google your statute and records, excuse me, and voting, and that will pull up the appropriate statute. So because you said you're under 6434, the particular statute is 6434 340 sub 6 sub G, which is voting outside of a meeting. So if you don't have enough votes received to approve whatever measure is out for vote, the board can extend the deadline for a reasonable period not to exceed 11 months. So if that means that if you're voting outside of a meeting, the board can extend. If you're voting at a meeting, the meeting is the time frame and voting can't go beyond that. It's not necessarily a time limit for approval. It's an expiration date for ballots. So typically amendments are done in a vote by mail procedure. Ballots basically expire at 11 months. But if you're trying to achieve a vote on an amendment or something like that at a meeting, the voting expires at that meeting. Ken, did you have anything to add to that?
No, I'm good. So the next question is, governing documents are not a contract between owners and the HOA, yet the HOA and owners are bound by them. Other than using the term governing documents, is there another legal term used to describe this relationship? A rules violation can result in a fine directed towards an individual owner, which has a different flavor than, for instance, a statement in the declaration as to the number of directors on the board. Wouldn't such rules have their own legal terminology other than rules? Okay, so I'll start with the second one. The statute uses the term rules, so I don't know that they would have any other legal terminology than rules. More broadly, they are part of the quote governing documents, end quote, which is also a defined term in WUCIOA. With regards to the relationship, it is true that some courts have stated that the relationship is not a contract because the owners didn't sign them, but it is what we might call a quasi-contract, meaning it's treated like a contract even though it's not a contract. And many courts have used exactly that term, quasi-contract. And other courts will treat it just like a contract, whether they call it a contract or not, because the covenant is a written document binding on both the owner and the association. So to some extent, it's not really relevant that it is or is not a contract. It functions in the same manner as a contract in that it is a written document binding on both the owner and the HOA. And the courts interpret them based on what the intent of the drafter is, in the same way that they interpret the intent in a contract. So did you have anything you want to add, Jennifer?
No. And we're at our last two questions, so we may have time for further questions. If you have any or have thought of something, please feel free to put them in the chat. So our next question is, are there any court cases this year of particular interest to associations or lessons we can take from them? So with the amount of legislative changes over the past few years, we're not going to see any court decisions on those statutory changes probably for another couple years. The reason for that is because, number one, owners have to be incensed enough or have enough of a strong enough position that they're willing to sue the association. Also, court cases out of the superior courts, so the first level courts, typically are not appealed. Appeals take time and take a lot of money. So we're not going to see, there usually isn't much, if any, court action year to year. So when there is a court case that is of particular interest to our community, you will see that broadcasted through WSCAI. We'll talk about it on the Zoom Q&As because it is so rare. So there hasn't been anything of particular interest this year that we're aware of. Ken, did you have anything to add to that?
No, I'm good. So the last question is actually one I've added in because of a number of issues that have come up the last month, and that is, what should the board or manager's focus be in dealing with a leak into a unit? And the short answer is you start by stopping the leak. You are trying to eliminate the source of water so that no more damage occurs. This is true whether people are complaining about mold or not. It's true whether it is a common element that's leaking or something inside the units that's leaking. You can chase money after the fact pretty easily, and you can parse through your governing documents or your rules or whether or not an owner was negligent or not after you've fixed the leak. You still have to use reasonable care in hiring vendors to stop leaks. But, I spent an hour last night going through I think it was an 8-page long demand letter from an owner wanting all kinds of stuff about a leak around her door, which had been going on intermittently for the past 8 years, and reviewing a 4-page response letter from another attorney for the association, trying to argue with the attorney for the owner about responsibility and duties of care and meeting fiduciary duties and the requirements of the declaration. And nowhere in any of the attorney's response did it offer that they would stop the water leak. And so the first thing you do when there is a leak is stop the leak. And if there is a need to immediately extract water from a unit, then it's reasonable to have the water extraction done. Whether or not you can assess the cost for that back to the owner or not is less important than getting the water stopped and taking care of any immediate problem. Whether or not there might be mold in a month is less important than stopping the water and removing anything which is immediately of concern. So I just want people to sort of remember that the first thing to look at is not how are you going to bill back an owner for the cost of stopping the leak. It is get the leak stopped. And there are a few exceptions to that general rule. And if you think you've got one, I'd suggest you contact an attorney and have enough information to help the attorney evaluate the leak so that they can help advise you on how to get it stopped. So anything you want to add on that, Jennifer?
I don't think so.
Okay.
So we have a few questions in the chat. The first one is, does the board always need to vote to go into executive session? And I'll take a quick stab. Yes. If you don't understand how that works, we have gone over board meetings and how to go into executive sessions quite a bit in prior Q&As. So if you search our YouTube channel and just the channel, not YouTube itself, for executive session, you will get a lot of hits. So yes, the statute is extremely clear that executive sessions can only happen from an open meeting. Ken, did you have anything to add to that?
Well, that is the correct answer as far as I'm concerned. And I understand there are some practical inefficiencies with that. So, for example, I had a meeting with a board of directors last night, and I'm quite certain they did not have an open board meeting which the membership could attend before they started talking with me. Technically, they should have called an open board meeting where they had provided 14 days notice to all of their owners. And the entire meeting would have, consisted of calling the executive session and then having a meeting with me. And there are some things where the practical efficiency are going to be outweighing the strict compliance. And in some cases, the board can make an evaluation about the risks involved, and they can just decide to ignore the statute. And I don't like to tell people to ignore statutes, but I recognize that it's certainly going to happen at times. And a lot of it's going to end up coming down to, is the board hiding activities from their membership by calling closed meetings or meeting with attorneys in private and not informing the owners about the subject matter? Or is it something which was urgent and had to be addressed, and they couldn't take the practical time to inform the owners in advance and give the owners a comment period? So I am certain we're going to end up with court cases. It's just going to take 2 or 3 years to get to the appellate level, where the courts are going to interpret for us what are reasonable exceptions to the strict wording of the statute. But in most cases, my recommendation is going to be just follow the statute. There's no reason not to have the motion for an executive session and do it as required by the statute. The legislature had some specific purpose in requiring that the subject matter of executive sessions be noted in the open meeting minutes before the executive session occurs. I don't know what the conspiracy theorists believe was happening, but I do know how the statute has been written now, and our recommendation is just comply. Anything you want to add, Jennifer?
No. So the next question is also about executive sessions. Why is an executive session required to be held at an open meeting when things are confidential and there are homeowners in attendance? Can a separate meeting still be scheduled? And I think we've pretty much covered that. Statute is extremely clear that executive sessions happen in an open meeting. So you can't schedule a meeting for an executive session without notice and opportunities for owner to comment.
So as to the why part, we don't know why the legislature does a lot of stuff. I will assume that there was some very vocal homeowners who believe that their boards are plotting and scheming all kinds of things in closed sessions. And so they got the legislature to put in this requirement that you had to tell the owners the subject matter of the executive session, even if it was appropriately something that would be, done in private, at least the owners would know what you're discussing. I don't know if this was intended to deal with threats of litigation or potential litigation against developers. I think there is a big developer lobby, and it may be that they are the ones that put this in so that before a board could go into executive session to discuss a potential construction defect lawsuit, they had to inform the owners that they were going to have a discussion about construction defects. So it may have nothing to do with the normal day-to-day operations of community. It may be specific to a developer motivated reason, but we just don't really know why the legislature does anything.
Okay, follow-up question. Does the subject matter of an executive session go into the minutes? Yes. So it doesn't have to be specific. If you're talking about a particular, delinquencies are going off of the list for executive sessions, but if you're talking about a particular delinquency, you can, before the statute goes into effect, just put delinquencies. When you go back on the record in an open meeting to take a vote, votes have to happen in the open meeting. Discussions happen in the executive session. So when you go back to the open meeting to take a vote, you can state however you are terming that particular issue. If it's a violation one from the executive session, you can use account numbers. There are different ways to term something to protect privacy if that's what you're trying to do. But the vote for that particular issue has to happen in the open meeting. Voting cannot happen in executive session. Ken, did you have anything to add to that?
No, I'm good.
So our last question in the chat that I'm aware of, Chelsea, do you have any more? So our last question in the chat is, RCC&Rs allow for car towing if the rules have been violated. Is this still illegal? So I'm not exactly sure what you're asking. If the association's governing documents, especially the declaration, give the association the authority to tow, you may have the authority to tow. It's not illegal for an association to have a vehicle towed as long as all procedures involving towing have been followed. So if you have a particular question on whether you can tow or how that procedure happens, contact your association attorney. We can't cover that in this Q&A. Ken, did you have anything to add to that?
There are some very precise statutory requirements for towing cars. There is a special towing court, which is a lot like a small claims court. And I can tell you that the towing court is particularly favorable towards the person whose car was towed. And so we are not big fans of towing cars, especially if you've not provided notice to the owner. especially if you know who the car belongs to and the car is towed without giving them an opportunity to move it themselves. It's just a high risk thing to do. And we have clients who are very upset with us when they get the letter from tow court, or we had one last month where the car belonged to a part-time resident. The owner moved back and, has a home in Alaska, so they spend part of the year in Alaska and part of the year in Seattle. And their car was towed while they were in Alaska, and then it was sold at auction because they didn't know the car was towed. And so, 2 months later, they come back and their car is gone and it's been sold at auction. So they had a demand letter to the association to reimburse them the cost of their car. And I'll say the challenge was that the best option for the association was probably to just pay her the money for the car rather than to fight the procedural issues that were involved in towing the car.
Just something brief to add. It's easier for owners to challenge board procedure than it is to challenge the substance of whatever action was taken. Procedure matters. If you have questions on how something should happen, contact your association attorney, get advice early so you're not having to pick up the pieces after the fact.
Yeah, this particular one, part of the issue was how notice was provided, in that the notice that was provided was not given to the proper address, which the owner had provided to the association, and they had provided an address in Alaska, but instead the notice had been sent to an older post office box, which the association had in their records.
We
All right.
may have time for one more question. Chelsea, was there anything else?
You covered everything that I saw.
Okay.
Great. All right. Well, we'll see everyone next week then. Thank you all.
Have a good week.